Yo, 12 messing with you. This is what we could do for you. Come through for the virtual hearing. Listen attentively and see what kind of case they got against you. Then run it through the large language model / AI. Figure out what kind of resources you got. Connect you with the best attorney for your situation, or provide a service of walking you through the steps as to filing on your own. It's a new model that we'd like to implement. Watch as I use my specific situation as a case study of sorts as to how this business model can serve clients. You see, them kids down here in South Florida been with me for a good minute now. This is the second go around. First time around, I got a no prosecute from the city of Miami who tried to hit me with a bull resisting without violence. You see, I suspect these crackers using that predictive policing model and low key creating simulations that they ain't even aware of. I guess that's their new move these days. It's just another way to get us caught up in that revolving door, in and out, in and out. But it's all good. Knowing is half the battle. You heard? They steady trying to engineer the winners and the losers. But if you with me, it's win, baby, win. And shit, I'm 1-0. About a year ago, the city of Miami tried to play me with some bullshit, resisting without violence charge. And 2 words, nol prosecute. Filed that motion to dismiss, and while it wasn't heard by the judge, I'm still proud of it though. Anyway, the city of Miami Shores hit me with another resisting without violence. Almost a year to the date of the city of Miami case, interestingly enough. This time around, one of them bass niggas dropped a knee on my back. So far, I filed a motion to correct my name based on a Scrivener's error, and then I also filed my motion to dismiss. I've yet to get any of my motions acknowledged, unfortunately, but this next hearing here is set to take place in front of the Honorable Judge Marcus Bach, Armas. On the screen, you'll see the Zoom login info. Join in and watch the spectacle. Watch how it plays out. These things are interesting, man. Here at Hip Hop Legal and Hip Hop Lawyers, our goal is to make law lit again. And how we gonna do that? Just by paying attention and using technology. Let me just point out where I'm at with mine. I ran it through a large language model, and here's what we're looking at. The core legal argument, fruit of the poisonous tree, quote unquote. I am absolutely right to question how one can be charged with resisting an officer without violence when the underlying predicate charge was dismissed nol prosecute. Typically, in criminal law, that is, if the initial detention or arrest was unlawful, then any charge stemming from unlawful interaction could be challenged under the doctrine of quote unquote fruit of a poisonous tree. However, resisting without violence, according to statute, that's Florida statute 843.02, is a bit of a gray area in this respect. Florida courts have ruled that even if an initial encounter was unlawful, a person still cannot resist an officer. But if the officers have no reasonable articulable suspicion or probable cause to detain you in the first place, that strengthens your argument that there was nothing lawful to resist. All right? And it says, number 2, the judge in this case has bypassed my motion to dismiss. AI tells me it sounds like the judge may be following a standard practice when motion to dismisses are not always immediately ruled on, especially in misdemeanor court cases where courts are flooded with routine matters. However, procedurally, if I did file a motion to dismiss, a pro se motion to dismiss, the judge should either rule on it or state on the record why it's not being considered. Also, the judge does not have to rule before the hearing if he deems it premature. I can also ask at a certain point and raise the issue to the court, bringing the motion to the court's attention. I can do this either before the hearing, during the hearing, or after the hearing by having my attorney speak up on my behalf. His name is Charlie Sachs, Esquire, by the way. He's been good thus far. Let's see how it plays out. He's a public defender, but a hard-working one. Okay, if the charges get dropped, can I still bring attention to my motion? Because this is what happens. They run you through this whole process. It takes your time, your energy, your finances, and then you're just kind of left with in a scenario where, at best, they're thinking that they're giving you a break, cutting you a break, if you will, for not, pursuing the case. But that's not the situation that I'm going through, and that's why I filed that motion to dismiss. But what I should do, according to the AI, is file a motion for judicial clarification, asking for a written order on my motion to dismiss, even if the case is dismissed. Now, here's the important part. If I get no response to that and they treat me like, I'm not even there, once again, I'll have to file a complaint with the judicial oversight body if I believe my due process rights were ignored. I can use this incident also in my federal case, which is on ice, to demonstrate a pattern of constitutional violations. The final strategy, before the hearing, again, try to tell the judge, speak to my attorney. During the hearing, I can also mention it. And again, even afterwards, if, for example, the case gets dropped, because that's what tends to happen, right? If it gets dropped, you have a window before the case is officially administratively closed. And within that window, you can still file other things. So I'm probably going to do that, depending on what happens, unless somehow they go through with it. Because they setting out the railroad, man. Sometimes you could feel it. So when you see the railroad getting laid out, you're going to lay down and let the train ride over you or move out of the way. But in some instances, hey, if it's just your time, it's your time. So if I got to do whatever amount of days for this little misdemeanor, then it is what it is. But what I really need is a ruling on my motion to dismiss for civil action later down the line. Take notes there. I also got a motion to correct a Scrivener's error. When they arrested me, one of the officers wrote my name down as Joel Vanderbilt Alexander. And for some reason, I keep getting letters to the crib for Joel Vanderbilt Alexander. So I'm like, could this be something that, they trying to set something later down the line when it comes to aliases and whatnot? So I asked the AI, I'm like, could this be a problem? And it was like, yeah, definitely. You absolutely should file a motion for judicial clarification regarding your pro se motion to correct a Scrivener's error, even after a nolle prosequi. The fact that you are still receiving court notices under the incorrect name suggests that this is a clerical error. This clerical error persists and could have long-term consequences, especially if it falsely creates an alias in your records. You see? Addressing the name discrepancy. A misidentification like this is not a minor issue. It can create a false alias, impact background checks. Now, again, you got a case where they gave me tickets. I wasn't driving. They put a completely false name, and all these games, man, just to waste time and to keep me off my purpose. You feel me? But that's another conversation. Anyway, so impact background checks and even cause legal headaches later down the road. If left uncorrected, it could be exploited in databases that flag aliases for law enforcement, employment, or legal matters. And this is very important at this moment, just checking out the job landscape out there. It's not easy, you know what I'm saying? So this is another problem that these folks have laid out for me. And again, the plausible deniability angle, one passes on to the other so they can obfuscate that it's a large scale racketeering influence in corrupt organizations kind of, this issue here. But, that's a conversation for another time. Anyway, so key questions and answers as it relates to the motion for judicial clarification. Even after nolle prosequi, again, you got that window where you could file different things. You know what I'm saying? So they could drop it, but don't just run off like, oh, shoot, I dodged a bullet. Unless you did. That's not the situation that was taking place. They ain't cutting me no break in this, and I don't want a break. I want the law to play out as it should. But now I'm going to file that motion for judicial consideration or clarification, that is, after the fact. Barring anything, happening to me in terms of me getting convicted. The officers didn't show up for the first hearing. We'll see if they show up for this one. But I imagine if they couldn't substantiate why they pulled up on me, they ain't gonna come in there and then say, well, he then reacted, abruptly or rudely. Like, that's not how the Constitution works. You can't go picking people off and saying that, hey, I'm gonna go just give this person a hard time, act tough with them, and then try to pull them for no reason. And then that person can't simply say, hey, what are you doing? And sort of back away. So, again, I got kneed. One of these dropped the knee on my back, yo. Anyway, it's the joint right here, man. Look, I love the law, so that's why I'm doing this. I'm showing that there's a business model here. Maybe somebody else might take it, man. I got too much on my plate. You know, they call me Mr. Side Quest. But the truth is, some of these side quests, they be adding it on, trying to hate. I'm passionate about this too, and if I could do it for someone out there, cool. But you can do it yourself. Learn how to adapt the AI to your circumstances and your predicament. That's my only suggestion. Anyway, so I did that, and I'm going to do this. Holla back. Gia. Message us at facebook.com/hip hop lawyers with an S. This ain't legal advice, by the way.